Swayam Prabha. Digital India. Educated India.
Hello all. So in last few weeks we have discussed extensively about the various competition law provisions in India as well as in European Union. So now we are all aware about regarding what are the anti-competitive agreements, what practices may lead to abuse of dominant positions in India as well as in Europe. And also in the previous classes you have seen lots of lot about the antitrust issues in your United States also. So these were all country specific rules regarding the competition laws, and now like we have to see how this competition policy has been perceived in the international trade arena. So looking at this thing, in this module we are going to read about the international trade and competition policy. Particularly we would look into the various provisions of competition laws in TRIPS agreement. So in this module we will be dealing with the brief history how this competition policy has been incorporated in the international trade and in particularly in TRIPS agreement, and what are the main provisions of the TRIPS agreement which talks about the competition policy. So there are three main provisions which directly points out at competition policy or competition law issues. So we would discuss one by one three of them, and so let us start with the brief history of competition policy in the international trade. So like the rules for investment as well as this competition policy, like in the international trade investment, then how the competition policy and investment will go side by side, that has been deliberated since 1940s. Particularly during the preparation of this GATT agreement, that is General Agreement on Trade and Tariffs. So during that time also, like it has been dwelled about how the competition policies can be incorporated in the GATT agreement, so that if there is certain monopolist situation arises or monopolistic issue arises during this international trade, that can be dealt. But as the international trade organization, the formation of international trade organization did not materialize, so these rules particularly on the aspects of trade and competition policy could not be finalized. However, the GATT as well as the like after the formation of the World Trade Organization, both GATT as well as the WTO are increasingly dealing with both the principles or the specific aspect of the trade, investment and competition issues. So they have laid down specific rules regarding like what can like if certain anti-competitive situation arises, how to deal with those kind of situation. And as well as the GATT as well as the GATT's agreement, like the General Agreement on Trade Services, both of them contains rules on monopolies as well as exclusive service suppliers. And particularly the rules on the monopolies has been extensively dealt in the commitments on telecommunications. The principles has been elaborately quite elaborated in the commitments on the telecommunication. And the TRIPS agreement, particularly the agreement on the agreement on the intellectual property and the services, both are now recognizing the national government's rights to act against any anti-competitive practices and their rights to work to limit these practices. So now which we will be discussing later in this module, like how the national authorities has been provided competence power to deal with the anti-competitive situation and what are their rights to stop or limit those practices. So this is just to introduce into the brief history where the competition policy was tried to incorporate it into the international trade agreements. Now, coming to the TRIPS agreement, as you all know, like TRIPS is the agreement on the TRIPS agreement, particularly the agreement on trade related to intellectual property rights. So, basically in the TRIPS agreement, the mandate of the agreement was to enact minimum provisions of the intellectual property rights, so that each member country which are part of the WTO agreement can formulate their national IP laws, keeping in this view of this minimum standards which are prescribed in this TRIPS agreement. So that so if certain IP issues arises, like both the countries would be able to like all the member countries will be in a position to respect or to balance the IP which each particular country gives. So as you like during 1970s and 1980s particularly, where during the negotiation of the International Code of Conduct on Technology Transfer, which did not materialize at the end, but during that negotiation the developing nations per se, they showed their reluctancy or showed their concern regarding the effect of IP monopoly. So, the developing countries in particular like they raised the issue that because the developed nation has maximum number of IPs or major share of IPs, the IP belongs to the developed nations. So, there is a chance of anti-competitive practices which like due to the IP monopoly. So, based on their concerns, concerns of the developing nation, finally it was thought that there should be some provision of competition policy in the TRIPS agreement. Like in that during that like not TRIPS agreement, during 1970s, the Code of Conduct on the Technology Transfer. Even that time the developed nations were not in favor of bringing any competition law clauses or competition policy in the agreement, because they have their own competition law at that time. But keeping to have a balanced situation or to create just to as a form of the negotiation, certain points on competition policy was incorporated in the later on in the TRIPS agreement. Particularly in the Uruguay round of discussion, then after the Doha declaration, there are certain the provisions regarding the competition policy were incorporated in the TRIPS agreement. So, these were not per se any policy, a stringent policy that national countries have to adhere, but these are kind of certain guidelines which the country has to take into consideration before enacting their IP laws. So, because we have to make it clear that the TRIPS agreement is all about the intellectual property related trade, and competition law does not per se include only intellectual property, it may include all kind of trade. So, here the provisions for competition policy were only related to intellectual property related trade. So, coming to the basic provisions of the competition law in the TRIPS agreement, there are three main articles which talks about the competition laws. First is the Article 8 subsection 2, then the second one which deals extensively is the Article 31 subsection K, and the third one is the Article 40. The Article 8 subsection 2 reads as follows: appropriate measures, provided that they are consistent with the provisions of this agreement, may be needed to prevent the abuse of intellectual property rights by the right holders, or the resort to the practices which unreasonably restrain the trade or adversely affect the international transfer of technology. So, here in this article, like TRIPS acknowledges that the member states may take appropriate measures to prevent the abuse of the intellectual property. So, here it did not specifically elaborate what can constitute an abuse of intellectual property right, but it gives us 3 pointers which can be considered as an anti-competitive behavior or the abuse of anti-competitive behavior in the perspective of the competition law. So, it gives the members power to adopt appropriate measures to prevent three interdependent kinds of IPR related practice. First, the abuse of IPRs by the right holders, it was directly mentioned. Second, practices that unreasonably restrain the trade. Third, practices that adversely affect the international technology transfer. So, these three has been directly mentioned in the article, but again interpretation of this article should not be restricted to these three. Even though like in WTO or in TRIPS the anti-competitive practices are not well defined, however, the WTO panel in the Mexico telecom cases, which was the first real competition case in the WTO, the term anti-competitive practices has been interpreted very broadly, and it may include actions that lessen rivalry or the competition in the market. So, any behavior or any action that may lead to decreased competition in the market. Then it may include the horizontal price fixing, market sharing agreements by the suppliers, which on national or international level are generally discouraged or disallowed. So, interpretation of the anti-competitive practices should not be restricted to those three which is directly mentioned in the article 8 subsection 2, but it can be interpreted broadly. Now, it depends how in which situation it has to be interpreted. Again, one of the drawbacks of this article 8 subsection 2 is as I mentioned, this TRIPS agreement is all about the like practices trade or trade related to intellectual property rights. So, the provision does not apply to other potentially anti-competitive practices which which is not directly related to the intellectual property rights, like normal mergers and acquisition or joint ventures where there is no IP per se involved, cannot be regulated by these provisions. So, this was the first article 8 subsection 2 which talks about the members country power to adopt measures to prevent the abuse of intellectual property right. Now, the very next article, article 31. Like article 31 gives the other measures where the in situation where a patent has not been fully used, or in case of national emergency or public health emergencies, such some patents are required and it was not available or not being given by the patent holder. So, in those cases the country may adopt measures such as the compulsory licensing system, where without the due permission from the patent holder they are the country may authorize other firm or company to produce the goods or the substances which involves the intellectual property. So, so one of the provisions of this article 31, article 31 subsection K, it reads as members are not obliged to apply the conditions set earlier, such as where such use is permitted to remedy a practice determined after judicial or administrative process to be anti-competitive. The need to correct anti-competitive practices may be taken into account in determining the amount of remuneration in such cases. So, basically these this article tells us that if the conduct of a patent holder is judged to be anti-competitive by a judicial or the administrative process. So, there should be a judicial or the administrative process, due process, that should determine whether a conduct is anti-competitive or not. So, if any conduct is found to be anti-competitive, then the competent authority of the member, it can authorize the compulsory licensing system neither with the prior negotiation with the patent holder. So, without prior negotiation of the patent holder, the member country has the power to authorize for the compulsory licensing, and it does not have to supply the product which involves the intellectual property to the domestic market necessarily. So, this clause gives the power to member country to issue the compulsory licensing for the product required, and it is not necessarily that the product has to be supplied in the domestic market. And finally, the determination of the amount of royalty or the remuneration is also is independent of this patent holders patent holders discretion. So, it may be the amount of remuneration may be smaller than that the case of the commercial transaction. Like if in a situation the patent holder has given a license for that technology, he may have asked for a higher amount, but when the member country is issuing a compulsory licensing, the remuneration amount is also negotiated and it may be a smaller amount as the country thinks so. Like one of the example for this kind of behavior, the unilateral conduct particularly, like where a patent holder refuses to give the technology or the IP. So, in one of the cases the US Federal Trade Commission FTC, like in the Rambus cases, like there are 4 patents which is like the Rambus has decepted the standard setting bodies by the exclusionary conduct by monopolizing the market with his 4 technologies. So, for these 4 technologies the compulsory license were granted and the maximum royalty rates were set which the Rambus could charge the firm. So, basically in that compulsory licensing negotiation, the rates were decided as 0.25% to 0.5% for 3 years, and after which the rate was dropped to 0. But the Rambus claimed that the average rate should be 1 to 2%, but as you may see it hardly exceeded from 0.5%. So, anyway, but Rambus was dissatisfied with this one, but the FTC held that the royalty rates unquestionably are better set in the marketplace, but given the anti-competitive conduct of the IPR holder, that is the Rambus, it has made impossible to deal that in the open marketplace. So, the FTC said although we do not relish imposing a compulsory licensing remedy, the fact presented make the relief appropriate and indeed necessary to restore competition, emphasis added. So, in order to restore the competition in the market and the monopoly thing which the Rambus has executed by not giving the license for those 4 technology in question, Rambus has created such a situation where the FTC is now bound to give the compulsory licenses with the rate decided by them. So, again article 31 subsection K is like the measures for the compulsory licensing can be issued by the member country. The next and one of the most important provisions are the in the IP and like TRIPS agreement is related to competition policy is article 40. So, now we have seen that the section 8 has provided the provided the power to the member countries to take necessary measures against any anti-competitive practices in the contractual licenses. So, as a specialized provision for this article 80, now article 40 stands as a specialized provision, and it provides that members agree that some licensing practices or conditions pertaining to the intellectual property rights which restrain competition may have adverse effect on the trade and may impede transfer and dissemination of the technology. So, the subsection 1 of this article 40 directly admits that the anti-competitive behavior of this IPR holder may have adverse effect on the trade as well as the dissemination of the technology, which is like which is a thing which we have seen in the competition law, like it is generally considered as an anti-competitive, and this article particularly acknowledges the fact. And it also goes to saying that nothing in this agreement shall prevent the members from specifying in the legislation licensing practices or conditions that may in particular cases constitute an abuse of intellectual property rights having an adverse effect in the competition in the relevant market. So, now so it has given the powers to the member countries to include in their legislation, or they can specify in their legislation that what may constitute as an abuse of intellectual property right, what kind of contractual licenses may become a part of anti-competitive behavior. So, here it says that as provided, a member may adopt consistently with the other provisions in this agreement appropriate measures to control such practices. Like such practices, again it goes on defining the practices which may lead to abuse of dominant position by giving some examples, and these examples were like exclusive grant back conditions, conditions preventing the challenge to validity of the patent or IP in question, or the coercive package licensing. So, in the relevant laws and regulation of the member. So, it gives an example what may constitute the practices which may lead to abuse of dominant position, and member country may adopt specific measures to put the details of what may constitute as an practices leading to abuse of intellectual property right. If you look now, if you analyze this section broadly, again the list of anti-competitive behavior here is not exhaustive, like it, and like it has given just few examples, like those 3 examples, like we have seen the exclusive grant back condition which I have underlined in this slide, the conditions preventing the challenge to validity, coercive package licensing. So, this is not very exhaustive list. Again, the interpretation should not be restricted to this only these 3 conditions or 3 practices, because as a part of the negotiation history of this TRIPS agreement, the Brussels draft listed 14 anti-competitive licensing practices which are also listed in the draft of International Code of Conduct on Technology Transfer, the 1985 version. So, there they have broadly classified what kind of practices may lead to abuse of dominant position, and 14 anti-competitive licensing practices were listed in that draft. So, article 40 subsection 1 and 2, like given the measures, like we now gone through that section, like what it says. Now, there are other provisions in this article, like article 40 subsection 2 to subsection 4. Now, it is basically the apart from the substantial procedure, these are the procedural rules. So, the article 40 subsection 2, 3 and 4 stipulates procedural rules for consultation and cooperation between a member who is enforcing its licensing related competition control and another member whose national or the domicile is alleged under the law of the former to be engaged in the licensing related to anti-competitive practice. So, in situations where a member country, when it is going for trade in another member country, it is like facing the anti-competitive behavior and which is regulated by the laws of the particular country, then in those cases what should be the procedure for the dispute solution is particularly laid in the subsection 2, 3 and 4 of the article 40. So, now after going through all these provisions, if you just read the article 40 subsection 1 without in connection with the other provisions, it was it seems to be an affirmative obligation imposed on the WTO member, but in reality it is not an obligation for the WTO members. These are certain guidelines or the leeways like which are given to the member countries, which like they may adopt in their national legislative national legislation. So, basically the national legislative bodies alone have the right to reasonably determine which practices are anti-competitive or the forbidden practice. So, it has just a kind of guideline which has been given. Now, it is up to the member countries to adopt or they list out the practices which may lead to anti-competitive behavior or the forbidden practices. So, like as per this article 40, for a WTO member to be able to complain before the WTO dispute settlement body that IPR related anti-competitive practices has been adopted in certain member countries and it has adversely affected the trade or impeded the transfer of the technology, then the member has to prove that the such anti-competitive practices are the effect of the action. That is, there is direct involvement of the company and the anti-competitive practices has led to this kind of the situation, and it is not by mere non-action of the second member in the private firm's anti-competitive conduct. So, now it has to be proved in the dispute settlement body that the anti-competitive practices are the effect of action. Only if there is in reality or direct involvement, then only the probable theoretical situation cannot be taken as a proof. So, it has to be proved that anti-competitive practices are the effect of certain actions. So, now so far we have dealt with all the 3 provisions mentioned in the TRIPS agreement, which is directly talking about the competition policy. Now, again interpretation, as we saw, there are certain example, specific example given for the, like, what may constitute abuse of dominant position and what are the anti-competitive practices. But again, these are not very exhaustive list, there are just few example. And the WTO laws cannot be read in clinical isolation from the public international law. The general rule for the interpretation, which is contained in the article 31 of this 1969 Vienna Convention on the Law of Treaties, the TRIPS agreement shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of their treaty in the context and in the light of its object and the purpose. Therefore, the anti-competitive practices which are mentioned in the TRIPS can be interpreted broadly. Now, all these provisions laid down in article 8, article 40 and 41 and 2 taken together, like, will be applicable for the anti-competitive practices relating to all the different IPRs covered by the TRIPS agreement. And like, it is just, as I mentioned earlier, it is not an obligation on the member countries. So, the competition rules in the TRIPS agreement do not contain precise obligation subjecting the exercise of the IPRs to the competition law principles. So, as per the TRIPS agreement now, like, if as we know, the TRIPS agreement lays down the basic minimum standards for the intellectual properties which the member countries should adopt. So, as per the TRIPS agreement, if the member country should adopt the minimum basic standards as prescribed in the TRIPS, there won't be any competition issue per se, but if the competition issues arises, then it has certain provisions by which the the member may adopt their own specific measures. So, this is not an obligation, now it is up to the discretion of the member states. And the article 8, 31 as well as the 40 of the TRIPS agreement recognize the powers of the member to control the IPR related anti-competitive practices. So, it just gives some pointers or the guidelines for the member countries to adopt specific measures to prevent the anti-competitive practices. Now, again, so now as per the TRIPS agreement, these are the basic provisions which member country may adopt. Again, it is not so easy to enforce the competition competition policy flexibility in member countries legislation, because the article 8 as well as the subsection 2 of article 40 limits the members' sovereign power to adopt competition legislation concerning the IPRs. How does it limit? So, the rules require that the measures adopted to control the IPR related anti-competitive practices to be consistent with the TRIPS agreement and should be appropriate. So, please take important note of the word consistent and appropriate. So, the member countries are not free to take any measures as they wish. So, it should be consistent as per the TRIPS agreement as well as appropriate. Now, again, appropriate is a very broad word. In general, it is open ended kind of thing, where like the member country as may think fit, may or as it appears to be necessary, the member country can take the appropriate measures. These three sections, like which we discussed, directly spoke about all the relevant provision related to the competition policy. However, the competition rules preventing the anti-competitive practices are also specifically addressed in the TRIPS note 3 of the TRIPS agreement, which says that for the purpose of the article 3 and 4, the protection shall include matters affecting the availability, acquisition, scope, maintenance and enforcement of the intellectual property rights, as well as matters affecting the use of the IPR specifically addressed in this agreement. Now, matters affecting the use of the IPR. So, basically if so this here comes the picture, the competition law. So, directly those three sections were quite relevant for competition policy. Also article 3 and 4 where the protection has been defined. So, there they have also taken the matter related to the competition issue. Again, the article 63 subsection 1, which deals with the transparency, also lists the subject matters of the TRIPS agreement, and one of the subject is prevention of abuse of intellectual property right. So, these are the two, article 63 and as well as the article 2, 3 and 4 also indirectly talks about the competition policy. and the WTO members exercise of its right to adopt or the enforce the domestic IPR related competition should be in principle of the good faith and must be consistent. So, member countries, that these flexibilities, competition law flexibilities are not that easy to enforce. It should be consistent and appropriate as per the consistent with the TRIPS agreement and appropriate as for the country. So, briefly we have discussed all the provisions which the TRIPS agreement is saying about the competition law. However, though these are like a guideline or pointers to the national or the members of the WTO, but again there are certain unanswered questions for all these provisions. Now, as we see, there are certain examples of the anti-competitive practices, but the even though that was listed in the draft negotiation bill of this, the 14 anti-competitive practices was listed there, but still the set of other practices which may constitute actionable abuse under the members competition law is missing here. Second, and again how to now, as we have seen the European as well as the Indian perspective, how to determine whether a behavior is anti-competitive or not. So, in whether we should go for a per se rule approach like cartel formation is like per se anti-competitive, or rule of reason approach like abuse of dominant position. So, we have to go by the rule of reasoning approach. So, under which standard the practices should be reviewed in here, and again like in the subsection K of article 31, where the compulsory licensing is in question, like where a process is found to be anti-competitive as per the judicial or the administrative process, what will constitute an adequate judicial or the administrative process? That definition or that clarity is missing also. And the appropriate remedies to be employed beyond general requirement of the consistency with the provisions of the agreement is also missing here. Again, the detailed guideline to enact and apply the national competition law to the IP related anti-competitive practices is also not here. So, it is kind of like a just few pointer where the where the member countries may just may refer to this condition and draft their or enact their national legislation on the anti-competitive practices for IPR related matter. And again, as this is for the TRIPS agreement, so these are all restricted to the trade related to intellectual property. So, it is not applicable for the normal competition anti-competitive behavior which is not related to the intellectual property. So, these are the basics provision just to give you a little bit awareness regarding how the TRIPS agreement has included the various provisions of the competition law, and apart from that how member countries are taking this as a guideline or how member countries are adopting this. So, I hope this is this will be quite useful to you regarding to to understand that competition policy is not just only a national matter. So, international trade also involves the competition law policy, and the TRIPS agreement has also taken care of this. So, in the next section we will just give you an example of the how EU has taken stance in case of this international trade or the international TRIPS agreement and the IP issues from the EU perspective, that we will deal in the next section. Stay tuned for that. Thank you.